Good afternoon and welcome to the First District Court of Appeal. We have two cases on the docket today. We will take a brief break after the first case to reconstitute the panel. Our first case on the docket is Bertram Sadis versus Hideaway Storage and Bridgefield Employers Insurance Company. Counsel, if you're ready, you may proceed.
Good afternoon, Your Honors. Mr. Beach, and may it please the Court, Tom Skolko here on behalf of the appellant Bertram Sadis. I'd like to reserve 4 minutes for rebuttal.
So noted.
This case presents a straightforward application of this Court's repetitive trauma case law. Every new exposure to repetitive trauma constitutes a new accident, and Mr. Sadis filed a claim for a new accident of 8/17/23 based on repetitive trauma, an accident that was never pled, it was never argued, and it was never adjudicated in the prior case. The summary final order that barred his claim conflicts with this Court's decisions in Smith, in Trosh, and in Rose versus Geico, fails to draw all inferences in favor of Mr. Sadis, which is required at the summary final order stage of litigation, and therefore should be reversed.
The situation here is a little different, though, from the cases that you cited. The injury that he alleges in the first petition for benefits is April of 23. The petition of benefits in October 23. So that case is resolved. This case, then, we've got an August 23 injury, which would have been within that same time frame and could have been encompassed by the October 23 petition for benefits, right? So why is that not subject to that petition?
Well, the encompassing argument that the employer carrier makes and that the JCC makes, I think the fundamental flaw of it is, well, there are several flaws, but the fundamental flaw of the argument is that while the JCC and EC claim that they accept that every exposure constitutes a new accident, they don't actually treat it as a new accident. And I think a simple hypothetical can show that.
Wait, I'm sorry, go ahead with your hypothetical, then I've got a follow-up.
Oh, okay. Yeah. If instead of alleging that on August 17, 2023, Mr. Sadis had experienced new repetitive trauma, if they had instead alleged that he fell down the stairs and landed on his wrist, causing carpal tunnel syndrome, nobody would be arguing, I don't think, that claim was barred by res judicata or collateral estoppel. Or maybe collateral estoppel is a separate issue, but wouldn't be arguing that it's barred by res judicata because it's obviously a different claim. Now you might respond, well, that's a totally new and different accident that's being alleged. That's different. But that's the point. Repetitive trauma is a new and different accident every time it happens. So just as you wouldn't bar a claim for a fall down the stairs, you can't bar an additional claim for additional repetitive trauma.
And I would agree with you if the second accident or the repetitive trauma were to happen after the initial petition for benefit were filed, but there's a statute that seems to me to be on point that I don't think either party argued, 440-192-9, which says a petition for benefits must contain claims for all benefits that are ripe, due, and owing on the date the petition is filed. Why does that not apply?
Because that statute would apply to different claims for the same cause of action. But that's the entire issue here. It's not the same cause of action.
But the injury as of October of 23, the August 23 injury, would have been known, right, when that was filed?
Yes, but the statute, plenty of provisions in Chapter 440 give a claimant a right. They have 2 years to file a petition under the statute of limitations. There's no obligation to file a claim for a separate cause of action.
But shouldn't there be in the context of repetitive trauma? I mean, this court has said with respect to repetitive trauma, and I note that the entire Chapter 440 uses the word repetitive once. So the guidance we have in terms of what the date of accident is for repetitive trauma looks at the last date of exposure, right? And on this record, the last date of exposure was the claimant's last day of employment, was it not?
It was, and that would have been truthfully, that might have been a problem for the original petition. The original petition perhaps could have been resolved much simpler than having a trial. It might have been resolved simply because that wasn't the last date of his exposure and therefore couldn't be his date of accident.
But under your reasoning, a claimant could have a date of accident on April 1st, April 2nd, April 3rd, with no end in sight in a repetitive trauma claim. And you would ignore all of the provisions. There are about 5 provisions in 440 that deal with a claim being ripe, due, and owing, and if not brought at a time when it is ripe, due, and owing, then it is deemed abandoned. And so are we to ignore all of those provisions and what the legislature has said about avoiding piecemeal litigation?
Those provisions all, to my understanding, deal with the same cause of action. You have to bring, if you have different claims that arise from the same cause of action, yes, you have to bring them all at one time. But this is a separate cause of action. It's just like Mr. Sadis fell down the stairs on August 17, 2023.
It's far different than I think that repetitive trauma claims are and here we're talking about the use of a blower. And the claimant said every day he went to work, he used a blower, and every day that's where the repetitive trauma. So it's not falling down the stairs every day. It is inherent in the nature of a repetitive trauma claim that whatever exposure, whether it's typing on a keyboard or in this case using a blower, that there is a continuing trauma. So why would we limit in the context of a claim that is clearly backward looking in August of 23 and in October when the PFB was filed, why would we limit it only to the way the claimant framed it as an April date of accident?
Well, again, I think that may have been a problem with the first claim being pled for April. I think the employer carrier may well have had a great argument that that claim could have been dismissed on summary final order because it wasn't the last day of his exposure, but it doesn't work in the reverse. I mean, if he had alleged, let's say that the dates were backwards. Let's say he had alleged first the August 17, 23 accident, and then later, after that was adjudicated, came back and alleged the April date. That makes sense that would have been encompassed because the date of accident has to be the last date of the injurious exposure.
But isn't the claimant trying to have it both ways? Because in fact, the claimant had a surgery in August of 23. The IME did not occur until the spring of 2024, so all of that was backward-looking and necessarily encompassed all of the claimant's exposures up until August of 23, and nothing in the record contradicts that.
Well, it only encompasses it if you don't treat it as an actual new accident. See, every day you're exposed is a new accident. It's even though it's not exactly the same as falling down the stairs, conceptually, this court's case law says it's the same. It's as if Mr. Sadis had fallen down the stairs 17 every day, up until August 17th. He would not be barred from filing those claims. He'd have the right to at least try to prove those claims, just like he has the right to try to prove these claims here. And I'm sorry, does that end?
No, I'm looking back at the statutory provision that Judge Bilbrey just quoted from. A PFB must contain claims for all benefits that are ripe, due, and owing on the date. And again, I think the fiction you're urging this court to adopt is to, whatever date the claimant chooses, if they don't use the last date of exposure, we're stuck with that, and that the JCC is stuck with that.
Well, no, I don't think they were stuck with that at all. I think that first petition, the first claim for the April alleged repetitive trauma could have been easily resolved by the employer carrier simply arguing that the date of accident for repetitive trauma is the last date of exposure, and this isn't your last day of exposure, therefore you don't have a valid claim, and that could have been resolved on that basis, but it wasn't. What they're trying to do is they're trying to now bar the later exposure that wasn't adjudicated, that wasn't clearly adjudicated in the prior order, and to use that as a basis to bar literally new accidents every day that happened between.
But the thing here, though, is that last date of exposure ended. It's somewhat unusual in that his employment terminated and that last date of exposure ended 2 months before the petition for benefits was filed. So I agree with you. Petition benefits is filed, and then 2 months later, he has to have some more surgery. Perhaps then a subsequent petition could be filed, or you could amend the petition. But this one, it seems like it's somewhat unusual in that his employment ends, the last date of exposure has occurred before the petition for benefits is even filed.
See, I really think that the timing issues, which the JCC and the EC pointed out, they only matter if you don't treat every day of exposure as a new accident. If you're really treating it as a new accident, as this court's case law says you must, what difference does it make when the treatment was?
So following up on Judge Rose's comments, then, does that mean for somebody that's still working at a place, they could file 2 years worth for each day of repetitive trauma all the way back to the start of the statute of limitations, file 700 and something petitions for benefits, claiming that each day was a new injury, and adjudicate every one of those?
No, I'm not saying that at all. The only legitimate date of accident that Mr. Sidis had here was August 17, 2023. He filed his earlier claim wasn't a legitimate claim at all. That's the problem. It's not that his August claim isn't legitimate, it's that the earlier claim wasn't legitimate. And
Well, assuming we agreed with you, what type of record would the claimant build in this new petition and new proceeding? I mean, he testified before the JCC in the first petition. He testified to all of his medical treatment all the way up to his IME, which occurred in 2024, which is at this point 6 or more months after his last date of employment.
Well, claimants often testify, about situations that happen after the petition's filed. There's nothing unusual about that.
I'm talking about that he's testifying as to his exposures, all of which occurred before the petition, all of which occurred before the IME.
Well,
What's going to change in a second PFB?
Well, of course, he could, present different evidence. Section 440.13.5, the IME statute, says that a claimant gets a new IME per accident. That means he could get a new expert to testify, and there's no reason that I can see why he couldn't present new or different evidence, either lay or expert. Of course he could present it. In fact, but to me and I realize I'm cutting into my rebuttal a little bit, but I just want to make the point that for collateral estoppel and res judicata to apply, the elements have to be conclusively proved. There can't be any question, right? The vagueness of the dates, which I think is what everyone's relying on, that's not a reason why his new claim should be barred. That's the very reason why it can't be barred, because there wasn't a clear adjudication. The judge in the earlier case didn't specifically adjudicate all dates of accident up through August 17, 2023. And I think I better reserve the remainder of my time for rebuttal. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Mr. Skolko, may it please the Court. My name is David Beach. I have the privilege of representing the appellee, the employer carrier below. The timeline in this case is absolutely critical. The claimant begins his employment in October of 2022. He continues working as a maintenance technician. Under his testimony and all of the evidence he presents, the only thing you'll ever find in this record is that it's his entire term of employment, from the beginning in October until he goes out on an unauthorized surgery without reporting the accident in August. He then files a petition for benefits in October, and now today argues that we somehow had the burden to correct his mistake, that we should have filed a motion for summary final order, despite the fact that there would have been a factual issue on whether that was the correct date of accident. So the claimant's arguing, the appellant argues, we filed the wrong date. And as a result of that, the employer carrier should be punished, and they should have to try this case again because they could have knocked it out. The petition for benefits filed before Judge Young was filed on October 30th of 2023. And as the panel has noted, everything had already happened. It's all backward looking. There can be no new exposures. Appellant argues today they could have had a new IME. They didn't. The record reflects the pretrial stipulation. They designate the same doctor for the IME. And more importantly, everything had already happened. There could be no history provided to the doctor that he hadn't already had when he saw him 6 months after his employment had ended. And so everything is backwards. The claimant chooses to allege an April date of accident, but then and the litigation stage is clear to everyone. The claimant, the claimant's IME, defense counsel, the judge, that we were litigating his entire term of employment. Nowhere does the claimant ever argue in this record that it was his employment in April that caused his condition, or his employment from October until April caused his condition. It's always my job. I go to work every day. It's the term of employment. The IME doctors ask, well, if he does it an hour a day, 5 days a week, would that be sufficient for a major contributing cause? More importantly, the doctrine of res judicata exists to prevent relitigating issues not only that have already been decided, but that could have been decided. And the doctrine applies when the following 4 items or the 4 identities are the same. Specifically, the identity of the thing being sued for, the identity of the cause of action, the identity of the persons or parties, and the identity of the quality or capacity of the person. Causes of action are the same for res judicata purposes if the evidence necessary in the second action would have been the same as what was presented in the first. And that's exactly what we have here.
Well, and the JCC below, and I know below the EC argued res judicata, why, though, does the statute that I'm citing not apply before we even have to get into judge-made doctrines of res judicata? The legislature said you got to add it in the petition for benefits, all claims that you have. A separate statute says any benefit due but not raised at the final hearing, which was ripe, due, and owing at the time of the final hearing, is waived. That's 440.25.4D. So before we even get into the judge-made doctrines, am I wrong that the legislature has said this is how it's got to be?
No, I don't think you're wrong at all, Judge. I think all claims that are ripe, due, and owing should have been filed. There is an interpretation that it would only apply to a specific date of accident or a specific claim.
But why should that interpretation apply in the context of a repetitive trauma claim? I mean, we've never said that, and the statute certainly doesn't say that.
And I don't think that it should, Your Honor. I think it's absolutely sufficient if the court were to determine to deny it on that basis, that claim was certainly right, because as you said, it's all in the past. Everything had already happened. That other date of accident, quote unquote, already exists. If he's going to pursue that litigation, this is not an instance where the claimant continues his employment, which is exactly what happens in Rose and Troche, and they're also in the context of statute of limitations, which is a very different issue. But if you're going to continue that employment, we're not talking about using it as a crystal ball and saying if a year from now he comes back to work and falls down the stairs 17 more times or continues to use the leaf blower, that we could deny that claim. That's not what happened here.
Well, the claimant seems to be making an argument as to this statutory abandonment claim that the employer carrier waived it by not raising it in the first PFB.
There's no way that the employer carrier could have done that. To file a motion for summary final order on a factual issue and say that the claimant is choosing the wrong date of accident without any evidence of what the accident date is would never survive. And in this case, the claimant chose that date and then litigated it as if it was all the entire period of employment.
Well, and in fact, the first JCC's order did expressly found that all claims that were not ripe, due, and owing were deemed abandoned, right? I think that JCC Young did that in the first page of her order.
That's correct, Your Honor.
So why shouldn't that be the beginning and end of this?
Completely satisfied if the court decides, based solely on that statute, we will gladly accept that opinion. I don't think it's the only reason, and I think there's significant difficulties with the Rose and Troche line of cases because it's in conjunction with the statute of limitations, which makes some sense if the claimant is continuing to have the injury and it's prolonging and they're having a time period of notice. And you also have 440.19.1, which says it's 2 years, and 440.19.2, which extends it an additional year every time the claimant receives a benefit. So the statute of limitations is already sort of a moving target. It's not a static date. What the claimant's position would allow is, as you stated, if the claimant works 5 days a week full-time employee. He works for 2 years. Well, that's 500 days. So he can come in and say, I was hurt on day 1. Fully present his evidence, develop everything he needs, have his day in court, lose, and do that 499 more times, just to continue to litigate it. And the case law, Gordon versus Gordon, the Florida Supreme Court stated that it's not just every justiciable or every issue that was actually adjudicated, it's every justiciable issue is then entombed forever. The claimant had the opportunity to present this case, and we cannot have, it's pure chaos, if every day of accident is an entire new claim. Not just a determination of when the statute runs, but he now has 500 dates of accident. That means he has 500 different average weekly wages. He has 500 potentially different maximum compensation rates. Florida statutes 440.13.2F allows 1 change per accident. If you don't like your doctor for any reason, you can pick a new one. If the claimant's take on this case law is correct, the claimant gets to do that 500 times. And also in this case, when the claimant lost and then refiles almost immediately with a different date of accident, has the judge recused. So what we really look at here is a case where the claimant fully tries his case, loses, is unhappy with the result, and goes judge shopping, and forces the employer carrier to incur the expense of trying the case a second time. It is clear that all of the evidence required in either claim or for any date of accident was fully developed and was available to the claimant. He knew at the time he filed the October petition when he had last worked. He knew when he had his surgery. He knew his claim that this was happening every single day. At any point there, he could have picked that date and filed the claim and had the one single final hearing, win or lose. Instead, the claimant has decided that, well, we go back and say, this is an entire new claim. They're not identical because in the first case, I said I had bilateral carpal tunnel. It was both of my hands. But now, once the judge realized that I had been dishonest about my prior treatment for the left, now it's only my right. It's a new claim. And instead of April, it's August, as if that makes any difference at all.
And that was actually going to be my next question. Where is this notion that a PFB can't encompass claims for more than one date of accident? And I mean, the statute, again, 440-192 sub 9, doesn't seem to limit itself to a petition raising only one date of accident.
I agree, Your Honor. There's absolutely no reason, as you stated, that the claimant could have, not only up until the time that he filed the first petition, but he still had the pretrial where he could have amended or filed a second petition. He could have alleged both dates. He could have alleged all dates. He just picked one. And he chose April, and he was completely satisfied with his choice until he lost, and now wants another 499 bites at the apple. And this is not a choice where a case where that was forced upon the claimant. Some of the cases cited in the reply brief suggest that if the defense suddenly raises a defense in their closing argument that the claimant wasn't aware of, sure, that's a totally different situation, but we didn't set this date of accident. The employer carrier had no role in choosing the claimant's date. What he chose to litigate, the claimant chose that. And then in the reply brief, it's suggested that the case of Caron versus Systematic Air Services is applicable and it would support their position. But in that case, that's a tort case followed by a contracts case. Different burden of proof. And that's not what we have here. This is exactly the same. It's the FESTA test. Did the claimant sustain repetitive trauma? Was that repetitive trauma significant enough to cause his condition? The cumulative effect caused the carpal tunnel and his need for benefits. And that's what he pled, and that's what the court had to decide. So it's exactly the same burden. It's not a separate cause of action. And then also in the appellant's reply brief, it's noted that we did not address the case of Seaboard Coastline, but I'm happy to accept that challenge here today. On page 865 of that decision, the fourth DCA stated, "We are keenly mindful of the principle that there should be an end to litigation. Parties should not be vexed more than once for the same cause. And therefore, Your Honor, we shouldn't have to try the exact same case, the exact same set of facts, the exact same IME doctor. And when you look at the language between the two petitions, the first petition in the record at page 152 describes the claim as, quote, as a result of repetitive activities associated with the employee claimant's employment, primarily of power blowing 8 to 10 hours per day. At the final hearing, it's confirmed the claimant testifies he never had overtime. He never worked more than 8 hours a day. The second petition is filed and states, quote, as a result of repetitive activities associated with the employee claimant's employment consisting of significant use of a power blower on a daily basis for a prolonged period of time. That is exactly the same claim. It's a semantics difference. It's form over substance. This is exactly the same claim that could have been brought, and in fact, it actually was. Because in opposing counsel's at the JCC level, in her closing statement, which is in the record at line 22 of page 240, she stated, quote, and that doesn't take away from the fact that there's uncontroverted medical evidence that his job with hideaway storage is the major contributing cause of his need for medical treatment and the major contributing cause of his injury. She does not say because of the event of April or because of his employment from October through April. She says it's his job. And that's what was litigated. Did his job, which partially consisted of using a leaf blower, cause the carpal tunnel, the subsequent need for medical treatment and surgery? The answer was no. And now the claimant wants to try the case yet again. Also in the record from pages 611 to 670 are the claimant's weekly checklists of his work activities. And those run from when he was hired in October of 2022 through July 28th of 2023. And the claimant put those into evidence. If their position is that the accident, we only litigated April, we didn't have anything to do with what was happening to the claimant after that date. It was set in stone. We were litigating an April 24th accident. Well, then how are his work activities in May, June, and July any way relevant to the claim they put before the JCC? It's absolutely not, because that's not what they intended. They knew exactly what they were doing. They were trying the issue of FESTA. Was there a repetitive trauma? Did it cause this condition? To now suddenly focus on this date is disingenuous. It's not what was done before, and it definitely creates chaos in trying to litigate cases in what is supposed to be a self-executing system, a case that is not to be piecemeal litigation. They developed their evidence. They had their day in the court. And Your Honors, unless there are any additional questions, we would argue that the JCC's order be affirmed.
Thank you, counsel.
A couple of things. Judge Rowe and Judge Bilbrey, you're correct that if it was the same cause of action, Mr. Siddish would be required to have litigated it in the prior case. But the only way it can be the same cause of action is if the petition actually raised it for adjudication. Applying the summary final order standard of review, you have to draw all inferences in favor of Mr. Siddish.
That's exactly contrary to what the statute said. It said it must contain all claims. You can't ignore the claims that you have. And
well, if you assume that it's the same cause of action, then you're correct. Then you've already decided the case. But it's not the same cause of action.
Where does 440 talk about that? Where does 440 talk about causes of action in terms of strictly dates of accident in a repetitive trauma claim?
Well, that's Smith for sure talks
No,
about.
I'm talking about the statute.
Oh.
Where does the statute say that?
Well, all those provisions, to me, are clearly addressing the within a cause of action. There can't be a different cause of action. Doesn't have to be pled or argued in a prior case. I mean, for example, my hypothetical, what if he had fallen down the stairs. Would that cause of action have to be included in the, of course it wouldn't. It's a new cause of action, and that's what this court's case law says every exposure to repetitive trauma is. It's a new case, it's a new cause of action. Mr. Beach's argument keeps saying it's the same case, but it's not the same case. Every exposure is a new accident that Mr. Sidis has to have a chance to prove. In Smith and in Rose and Trosh, this court laid out a test to prove exactly what Mr. Sidis would have to prove here, which is continued exposure and legal causation. How can he be denied the chance to even develop evidence to meet that test? That's not a test at all. That's a fiction. He has to be given the chance to do so. And I agree with you. I mean, if you think the statute, requires all causes of action to be raised in a petition, I've never seen that before. I don't think there's any authority for that. I think the petition must raise all claims that are ripe, due, and owing for a particular cause of action, but that's a different date of accident. It's not the same cause of action, at least according to this court's decisions in Rose, Trosh, and Smith.
Well, thank you, counsel. Your time has
All right.
expired. We will stand in a brief recess to reconstitute the panel for the second case.
Thank you very much.